Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to share with you really good news. It's news about new memo from EOIR, or Executive Office of Immigration Review, regarding how they're going to be processing cases in the light of the DHS prosecutorial discretion memo. Basically, we're seeing the return of termination, motions for termination and prosecutorial discretion. The same thing that we saw when the Obama administration took over. We're going to see it during the Biden, the new administration. I'm very happy about that because, as the memo mentions, currently there are over 1 million cases. The memo cites 1,300,000 immigration cases pending in immigration courts. And of course, this memo and this new approach, rather, will help to basically free up the docket and resolve cases that should not be in immigration court. For example, cases that of people who can adjust at USCIS or maybe people who should really enjoy prosecutorial discretion while they're waiting for their petitioning child to turn 21 or something of the sort. So let's talk about this memo. This memorandum was issued just today, June 11, 2021. And it says that it reminds rather the immigration judges about, of course, their independence, and also that we are entering the time of new enforcement priorities where cases, or rather people and respondents' cases, have to be evaluated from the point of if they present national security concern, border security, or public safety concern. If not, then this case does not fall into an enforcement priority. Hence, prosecutor can exercise their discretion. Okay. It also says basically that the judge is there to resolve the disputes, hinting that if the prosecutor agrees to drop the case, nothing should stop the judge to drop the case. So the news is great. And again, EOIR Memo says that the government attorneys have power to issue, reissue, serve, file or cancel notice to appear, oppose or join motion to reopen. They can request that proceedings be terminated or dismissed, termination, and they may exercise their discretion regarding the appeal. For example, government attorney may choose not to appeal positive decision for your client or for yourself if you're representing yourself. And it's fantastic. The judges are directed that at the hearings, they have to ask questions about if the case represents an enforcement priority. Will the prosecutor exercise their discretion? Will the case be terminated or dismissed? And if it can be administratively closed. The memo says that administrative closure currently is available in the 3rd, 4th, and 10th federal circuits. In the 6th federal circuit, administrative closure is available also if the respondent would like to pursue naturalization, if, of course, they're eligible. The same principles should be applying to the Board of Immigration Appeals, and the judges are also reminded that they can exercise all docketing powers they have, meaning that perhaps they can continue the case if they would like. They can use those dockets as we saw for special immigrant juvenile cases, special dockets when the case is kind of like getting off the docket and later can be reactivated. So this is fantastic news. Basically, termination, it seems, is back. So would be administrative closure for the districts I mentioned. And we're going to see what's going to happen with the rest of the country. And I want to congratulate all of us, especially those who are in removal proceedings. Now, a couple more things I would like to share with you, because this is not it for good news. Prosecutors also stated that they will be exercising their discretion through November 16th, 2021, with regard to cases, removal and deportation cases, that fall under Ms. Chavez case. This is the case I spoke in one of my videos about, where Supreme Court, the United States Supreme Court held that if you were served with a notice to appear that did not contain date and time of the hearing, and later you were served with a hearing notice, such a service did not stop your time for the cancellation of removal relief, meaning that pretty much everyone, guys, who had an old order of removal should consult with an attorney to see if they may be able to reopen their case and file for the cancellation of removal if now they're eligible. To file for the cancellation of removal, you need to show that you've been in the United States for 10 years and those 10 years were not interrupted by service proper service of the notice to appear that contains date and time of the hearing. You didn't receive an arrest or conviction for certain disqualifying offenses. You have a qualifying relative like U.S. citizen or green card holder, spouse, parent, or child who will experience extreme hardship, or rather exceptional and unusual hardship in case of your removal. All right. So if you have an old order of removal, make sure you have your records, FOIA them if you have to, consult with an attorney to see if you can reopen your case and file for cancellation of removal. Great news. The prosecutors confirmed that they will be exercising their discretion. Rather, it says they are expected to exercise their discretion through November 16th, 2021. So it's not forever. It's 180 days from the date of or 6 months from the date United States Supreme Court held that old cases can be reopened based on a defective service. Very, very important. So again, share this good news, share this video. Please subscribe to my channel, like this video, and stay updated. I hope to see you soon.